Statute 83.49. 1. Whenever money is deposited or advanced by a tenant on a rental agreement as security for performance of the rental agreement or as advance rent for other than the next immediate rental period, the landlord or the landlord's agent shall either A. Hold the total amount of such money in a separate non-interest bearing account in a Florida financial institution for the benefit of the tenant or tenants. The landlord shall not commingle such monies with any other funds of the landlord or hypothecate, pledge, or in any other way make use of such monies until such monies are actually due the landlord. B. Hold the total amount of such money in a separate interest-bearing account in a Florida financial institution for the benefit of the tenant or tenants, in which case the tenant shall receive and collect interest in an amount of at least 75% of the annualized average interest rate payable on such account or interest at the rate of 5% per year, simple interest, whichever the landlord elects. The landlord shall not commingle such monies with any other funds of the landlord or hypothecate, pledge, or in any other way make use of such monies until such monies are actually due the landlord. Or C. Post a surety bond executed by the landlord as principal and a surety company authorized and licensed to do business in the state as surety with the clerk of the circuit court in the county in which the dwelling unit is located in the total amount of the security deposits and advance rent he or she holds on behalf of the tenants or $50,000, whichever is less. The bond shall be conditioned upon the faithful compliance of the landlord with the provisions of this section and shall run to the governor for the benefit of any tenant injured by the landlord's violation of the provisions of this section. In addition to posting the surety bond, the landlord shall pay to the tenant interest at the rate of 5% per year, simple interest. A landlord or the landlord's agent engaged in the renting of dwelling units in 5 or more counties who holds deposit monies or advance rent and who is otherwise subject to the provisions of this section may, in lieu of posting a surety bond in each county, elect to post a surety bond in the form and manner provided in this paragraph with the office of the Secretary of State. The bond shall be in the total amount of the security deposit or advance rent held on behalf of tenants or in the amount of $250,000, whichever is less. The bond shall be conditioned upon the faithful compliance of the landlord with the provisions of this section and shall run to the governor for the benefit of any tenant injured by the landlord's violation of this section. In addition to posting a surety bond, the landlord shall pay to the tenant interest on the security deposit or advance rent held on behalf of that tenant at the rate of 5% per year simple interest. 2. The landlord shall, in the lease agreement or within 30 days after receipt of advance rent or a security deposit, give written notice to the tenant which includes disclosure of the advance rent or security deposit. Subsequent to providing such written notice, if the landlord changes the manner or location in which he or she is holding the advance rent or security deposit, he or she must notify the tenant within 30 days after the change as provided in paragraphs A, D. The landlord is not required to give new or additional notice solely because the depository has merged with another financial institution, changed its name, or transferred ownership to a different financial institution. This subsection does not apply to any landlord who rents fewer than 5 individual dwelling units. Failure to give this notice is not a defense to the payment of rent when due. The written notice must A. be given in person or delivered by mail or email in accordance with Section 83.505 to the tenant. B. State the name and address of the depository where the advance rent or security deposit is being held, or state that the landlord has posted a surety bond as provided by law. C. State whether the tenant is entitled to interest on the deposit. D. Contain the following disclosure. Your rental agreement requires payment of certain deposits. The landlord may transfer advance rents to the landlord's account as they are due and without notice. When you move out, you must give the landlord your new address so that the landlord can send you notices regarding your deposit. The landlord must provide you written notice in person, by mail, or by email, in accordance with Section 83.505 Florida Statutes within 30 days after you move out of the landlord's intent to impose a claim against the deposit. If you do not reply to the landlord stating your objection to the claim within 15 days after receipt of the landlord's written notice, the landlord will collect the claim and must mail you the remaining deposit, if any. If the landlord fails to timely provide you notice, the landlord must return the deposit, but may later file a lawsuit against you for damages. If you fail to timely object to a claim, the landlord may collect from the deposit, but you may later file a lawsuit claiming a refund. You should attempt to informally resolve any dispute before filing a lawsuit. Generally, the party in whose favor a judgment is rendered will be awarded costs and attorney fees payable by the losing party. This disclosure is basic. Please refer to Part 2 of Chapter 83, Florida Statutes, to determine your legal rights and obligations. 3. The landlord or the landlord's agent may disburse advance rents from the deposit account to the landlord's benefit when the advance rental period commences and, without notice, to the tenant. For all other deposits, A. Upon the vacating of the premises for termination of the rental agreement, if the landlord does not intend to impose a claim on the security deposit, the landlord must return the security deposit, together with interest if otherwise required, within 15 days after the termination of the rental agreement. If the landlord intends to impose a claim on the deposit, the landlord must, within 30 days after the termination of the rental agreement, provide the tenant written notice by certified mail to the tenant's last known mailing address or by email in accordance with Section 83.505 of his or her intention to impose a claim on the deposit and the reason for imposing the claim. The written notice must contain a statement in substantially the following form. This is a notice of my intention to impose a claim for damages in the amount of upon your security deposit due to. It is sent to you as required by Section 83.49(3) Florida Statutes. You are hereby notified that you must object in writing to this deduction from your security deposit within 15 days after the time you receive this notice, or I will be authorized to deduct my claim from your security deposit. Your objection must be sent to landlord's address. If the landlord fails to give the required written notice within the 30-day period, he or she forfeits the right to impose a claim upon the security deposit and may not seek a set-off against the deposit, but may file an action for damages after returning the security deposit to the tenant. B. Unless the tenant objects to the imposition of the landlord's claim or the amount thereof within 15 days after receipt of the landlord's notice of intention to impose a claim, the landlord may then deduct the amount of his or her claim and shall remit the balance of the deposit to the tenant within 30 days after the date of the notice of intention to impose a claim for damages. The failure of the tenant to make a timely objection does not waive any rights of the tenant to seek damages in a separate action. C. If either party institutes an action in a court of competent jurisdiction to adjudicate the party's right to the security deposit, the prevailing party is entitled to receive his or her court costs plus a reasonable fee for his or her attorney. The court shall advance the cause on the calendar. D. Compliance with this section by an individual or business entity authorized to conduct business in this state, including Florida licensed real estate brokers and sales associates, constitutes compliance with all other relevant Florida statutes pertaining to security deposits held pursuant to a rental agreement or other landlord-tenant relationship. Enforcement personnel shall look solely to this section to determine compliance. This section prevails over any conflicting provisions in Chapter 475 and in other sections of the Florida statutes, and shall operate to permit licensed real estate brokers to disburse security deposits and deposit money without having to comply with the notice and settlement procedures contained in Section 475.251d. 4. This section does not apply to transient rentals by hotels or motels as defined in Chapter 509 or in those instances in which the amount of rent or deposit or both is regulated by law or by rules or regulations of a public body, including public housing authorities, and federally administered or regulated housing programs, including Section 202, Section 221d3 and 4, Section 236, or Section 8 of the National Housing Act, as amended, other than for rent stabilization. With the exception of subsections 3, 5, and 6, this section is not applicable to housing authorities or public housing agencies created pursuant to Chapter 421 or other statutes. 5. Except when otherwise provided by the terms of a written rental agreement, any tenant who vacates or abandons the premises before the expiration of the term specified in the rental agreement, or any tenant who vacates or abandons premises which are the subject of a tenancy from week to week, month to month, quarter to quarter, or year to year, must give at least 7 days written notice by certified mail or personal delivery to the landlord before vacating or abandoning the premises, which notice must include the address where the tenant may be reached. Failure to give such notice relieves the landlord of the notice requirement of paragraph 3A, but does not waive any right the tenant may have to the security deposit or any part of it. 6. For the purposes of this part, a renewal of an existing rental agreement shall be considered a new rental agreement, and any security deposit carried forward shall be considered a new security deposit. 7. Upon the sale or transfer of title of the rental property from one owner to another, or upon a change in the designated rental agent, any and all security deposits or advance rents being held for the benefit of the tenants shall be transferred to the new owner or agent, together with any earned interest and with an accurate accounting showing the amounts to be credited to each tenant account. Upon the transfer of such funds and records to the new owner or agent, and upon transmittal of a written receipt therefor, the transferor is free from the obligation imposed in subsection 1 to hold such monies on behalf of the tenant. There is a rebuttable presumption that any new owner or agent received the security deposit from the previous owner or agent. However, this presumption is limited to 1 month's rent. This subsection does not excuse the landlord or agent for a violation of other provisions of this section while in possession of such deposits. 8. Any person licensed under Section 509.241, unless excluded by the provisions of this part, who fails to comply with this part, is subject to a fine or to the suspension or revocation of his or her license by the Division of Hotels and Restaurants of the Department of Business and Professional Regulation in the manner provided in Section 509.261. 9. In those cases in which interest is required to be paid to the tenant, the landlord must pay directly to the tenant or credit against the current month's rent the interest due to the tenant at least once annually. However, a landlord is not required to pay interest to a tenant who wrongfully terminates his or her tenancy before the end of the rental term. We offer real estate, estate planning, probate, and business law. Call 321-206-3603 or visit easlerlaw.com to book a consultation. Offices in Melbourne, Florida. Virtual consultations worldwide.